to me. I'm undercover police, guys. Back off. Back off. You hear me? Copper, come help me.
Stop filming. Stop filming.
Stop! Stop! Get away from me!
Block their cameras.
Get away from me! Don't block my camera! Don't block my camera!
Do you see what's going on? Do you see what's going on? The cops are blocking the cameras. It's your First Amendment right to film. California legislature, New York legislature, Chicago, Florida, we need a bill. Blocking the cameras is a fireable offense for violating my First Amendment right. These guys should never have their cameras blocked. This man could be dead. He's not doing a public service by blocking out justice. If you block the camera, you should be fired. Thanks, guys. Thanks.
Or,
Caroline Products, this case in 1938. Caroline, today is both a fundraiser and a giveaway. When I took over this office space in the beginning of 2021, I told my executive producer that it would be self-sustaining. And it hasn't been. I've put all my time and energy into building the historical institution of racism that the Supreme Court is. That's what I've spent my time doing. I broke my thumb, I didn't get surgery, I just kept building this wall. So, it is what it is. So, I have to raise $3,000 today. There's no other way to say it. Or I'm gonna lose this office space, which includes this wall. I've got pictures of it, I could recreate it somewhere as soon as I get another office, but that's what's going on today. So I'll give away as many as I possibly can. I've made as many videos as I can, so I'll just keep going. I'll see you guys. Today, when we talk about defunding police and switching that money over other agencies, you say, well, how come, why? Because we have a monopoly on power within our police system, and two specific cases jump out at me like a laser beam. It's gonna be Warren versus District of Columbia, where 3 women are gang raped all day long for like a marathon 16-hour raping. I'm not kidding. They had called the police and begged for help, and they said, oh, we're on our way. They knocked on the door and nobody answered. Yeah, they're being raped. And the Supreme Court said, no, you don't have to be protected by the police. And then again, in Castle Rock versus Gonzalez, Ms. Gonzalez called and said, I got a restraining order on my ex, husband, fiance, whatever he was, and said I think my 3 kids with him are in danger. He went to the house, stole the 3 kids after she called. They didn't go to the house. He then goes to the police station and kills the 3 kids in the police station, has a shootout with the police, and the Supreme Court says they don't have to protect us. So why do they have a monopoly on power? What are we paying for? When we talk,
How you like that?
let's talk about prison and the war on drugs. This is 1920. The first jump in our prison industry is during Prohibition, when we criminalized a chemical. Notice, it's flatline. There's nobody in jail. How come that is? Because our country is founded on the principle of liberty, that you're free and you don't go and live in a cage. Then right here, Terry passes in 68, and as you know, you saw the stick on there, that's when the prison industry starts. But the real helper to the prison industry is Richard Nixon. He creates the war on drugs. He creates it because the Vietnam War is going on and he can't get a handle on the community. So take a look at that prison industry. Go back and take a look at this prohibition. Officer Madwin, how you doing?
Hey there. Just want to let you know the number one reason I arrest someone is because of drugs or because I think they have drugs.
You think? What does that mean?
It means I can send him to prison either way and let the courts figure it out.
He can arrest you because he thinks you have drugs. Let's talk about, when you talk about people being legally departed, it's because of Supreme Court laws. Breonna Taylor was killed by a confection of different laws over the past several decades that have just completely stripped away our Fourth Amendment right. And so she was first killed by Wilson versus Arkansas, that RBG was all for. And then this attaches to Terry versus Ohio, because you can't have Wilson without Terry, as you know. And then Kerr was extended to Wilson, but then Kerr goes back to Brenniger. And what Brenniger says is that if a man of reasonable caution, a cop, and he has reasonable caution to believe that he has trustworthy information, there could be a crime going on in your house, he can just go right in the door. And that's extended from Carroll versus United States, which is based on prohibition in Oklahoma. But that's how Breonna Taylor was no-knock rated, those cases. When you talk about quick takeaway for you. You can say anything you want to the police. In a case called City of Houston versus Hill in 1987, Mr. Hill interrupted the police while a confrontation was going on between him and his friend and the police. The police arrested him, took him to jail. He sued all the way up to the Supreme Court, and amazingly, the Supreme Court upheld our First Amendment right and even said that using what police would deem fighting words, saying that I could kick your ass, are not actually a violation of the First Amendment, because there are statutes on the law books that if someone is to assault a police officer, they would be arrested for that statute. So in other words, your free speech is not limited. It is not limited at all. You can say whatever you want. You can even interrupt their investigation. The ruling is right there. It's right there. Listen, take it away. And if a cop comes up to you and says anything bad to you, you can tell him to go fly a kite. You may have just celebrated Juneteenth as the day blacks were freed in America, but it's not true at all. The day blacks were freed in America, May 17th, 1954, Brown versus Board of Education desegregated America. Amazing. How come that happened? It was passed by Earl Warren in the Warren Court. What a humanitarian. Not at all. Earl Warren was a power monger, a Freemason, and he'd won every election he'd ever run out for, except for when he ran for president as vice president, not on the head of the ticket. He sat at FDR's table in 1942 and convinced him to lock up 100,000 Japanese because of World War II. Korematsu versus United States sued and said, hey, you locked me up because of my race. Earl Warren was not on the court, but the 7 Supreme Court justices who FDR appointed said, no, it wasn't racist at all. So Earl Warren desegregated because he wanted to know what was going on in black restaurants, black hospitals, black schools. And because he didn't know that, he desegregated America. You may celebrate Juneteenth. It's just not true. Miranda versus Arizona means that police have to read you your Miranda rights. Your Miranda rights are that you have the right to remain silent. This goes back to the 5th Amendment of the Constitution that says you don't have to self-incriminate yourself. That's part of the due process of the Constitution. That's how we have our freedoms in the Bill of Rights. When the police say you have the right to remain silent, when the police kicked down my door, Chief of Police Michael Moore kicked down my door, he told me kids were dying. So I told him everything I possibly could tell him to try to help him because he told me kids were dying. And I hadn't done anything wrong. I was innocent. So everything I said to him, he then twisted and distorted and said that I said something else. When the police say you have the right to remain silent, use it. Here's what you say. Am I being detained or am I free to go? You're being detained. Great. I plead the 5th Amendment. I'd like to get my attorney now, please. If I had kept my mouth shut, you never would have met this wall. Miranda, the reason why there are window tinting laws in America is gonna blow your mind. Matt versus Ohio passes in 61, and police can no longer just grab you to get evidence off of you or just run in your house and obtain evidence against you and violate your civil liberties. In 63, McFadden violates John Terry's civil liberties by just grabbing him. So the Ohio State Supreme Court throws the case out because of Matt versus Ohio. The Supreme Court overrules the Ohio State Supreme Court, goes against their own ruling to convict John Terry so that police can just grab people. In a case of 1971 called Coolidge versus New Hampshire, this is a murder case where they get a warrant for Coolidge's apartment. They go in there and they see the gun on the table, but they don't have a warrant for the gun, so the gun is inadmissible. The Supreme Court personnel then talk about, oh, it's in plain sight, it must be admissible. It wasn't. 8 years later, the FBI passes the Plainview Doctrine. If they see it, then that's not a violation of Matt versus Ohio. That's why you can't tint your windows in any state in the union anymore, so they can see into your car. The reason why, there's a couple ways you could look at DeJong versus Oregon. You could look at it that a broken clock is right twice a day, and the Supreme Court got it right. Or you could just say that Kirk DeJong was white, and he was for the Communist Party. But what he was doing was protesting police brutality in 1934. See, the people of America have never liked the police in this country. And anybody who does bought into a slogan or a paid campaign. They really don't like the police because when the police swoop in behind them, their stomach goes through their chest just like yours and mine does. Kirk DeJong is protesting police brutality, and Oregon creates a law called the criminal syndicate. If you speak out against the government or police, then you're doing a criminal act. Kirk DeJong has this case heard at the Supreme Court, and they rule in favor of the First Amendment, that you have a right to assemble and speak out against the government like we're doing here and now. The people of America have never liked this policing system. DeJong gives us this right to assemble here and now. There's a Please make sure you have.
There are customary rules.
We have a limited window to overturn Terry. Susan B. Anthony in the 1860s is on the verge of getting the women right to vote. She has to abandon her mission because there can only be one message. And so she collects 400,000 signatures to abolition slavery. She gives up her mission. It doesn't happen until 1920 with the 19th Amendment. She dies in 1906. She doesn't get to see it happen. Rutherford B. Hayes, 1870 to 1876. Rutherford B. Hayes ends in construction for everybody. 6 years later, the entire movement's over. We have a window. Jackson Giles sues, goes to the Supreme Court twice, 1903, 1904. He misses his window. It doesn't happen until 1965. Matt versus Ohio says police can't just run in your house and grab evidence against you. 2 years later, the Supreme Court passes curve that says cops, all they have to do is knock an ounce and run in. 64 Civil Rights Act passed, which gives you freedom. 4 years later, they allow cops to discriminate against you. If we don't get the overturn Terry hashtag going, we're gonna miss our window. We gotta get it going. We're gonna miss our window. We talk a good game here in America. Our country is founded on the principles of liberty, due process, and freedom. But unless you get in trouble, and then you will be a slave and live in a penal system, a lot like North Korea. Are there any other countries in the world, that says freedom and free, and then has a slave system attached to their liberty system? We're based on liberty, unless, of course, you used to be a slave and then we'll arrest you, make you a slave again. Oregon versus Buckley passes in 1926, and the Supreme Court rules that racial restricted covenants can be upheld and you cannot sell your house to a black person. That ruling is overruled in Chille versus Kramer in 1948. That the Supreme Court rules that racial restricted covenants won't be legally binding any longer. You can't prosecute anybody for violating a racial restricted covenant. That's criminally. So then the housing market's solved, right? In 1948? Maybe not. What happens? So Chille versus Kramer just decriminalizes it if you have a racial restricted covenant on your home. So then if a neighbor sells their house to a black person or a Mexican, then what the other neighbors will do is they'll sue that person civilly, because they still have a racial restricted covenant on the record. It's not criminally indictable, but it is civilly. So you go to sell your house and 5 neighbors sue you? And that's how housing is still messed up in America today. We talked yesterday about the cases that killed Breonna. Ruth got Wilson going, which was passed by Terry, which Kerr's extension into Wilson, and then you got Brinegar. So what is Brinegar so bad for? How come Brinegar so awful? Because Brinegar takes your 4th Amendment right and gives it to the police. Remember, your 4th Amendment right says that no warrant shall be issued but upon probable cause, sworn by oath or affirmation. In other words, you've made me a victim by breaking the law. I went down and filed an oath and affirmation against you that you made me a victim. Brinegar says that probable cause exists where the facts and circumstances within the officer's knowledge and which they have reasonable, trustworthy information, and he's a man of reasonable caution. Were the men who killed Breonna Taylor men of reasonable caution? This goes against our 4th Amendment. It's unconstitutional. It needs to be overturned. Brinegar versus United States, 1949. No warrant shall be issued, sworn by oath or affirmation. Probable cause exists in a cop's head? That's not probable cause. This is unconstitutional, and it killed Breonna Taylor. We talked yesterday. The cases that killed Eric Garner are Atwater versus City of Lago Vista, Terry v. Ohio, and Graham versus Connor. So surely Graham versus Connor barely squeaked by. The case that says that the reasonable officer on the scene will use objective reasonableness in the amount of force that they use. So we've talked about this. You cannot be objective about the situation you are the subject in. We talked about this. So surely though, Graham versus Connor with John Paul Stevens and William Brennan and Thurgood Marshall on the court, surely this passed 6-3 or even 5-4. No, this passed unanimously 9-0. That the reasonable officer on the scene will decide how much force to use on you or your brother or your dad or your uncle or your family. And so when you say, hey, how come Thurgood Marshall would vote for this? Because they're all bad. Thurgood Marshall also voted for Terry laws. You celebrate Ruth, you celebrate Thurgood, you celebrate Anthony. They're all tyrants. We got to overturn Graham versus Connor. The cases, when I see people who get killed by the police, in my brain, it immediately ties to a Supreme Court case. And that's kind of why I built the wall, but I wanted to be able to illustrate the exact damage that the Supreme Court cases do into our culture and our community. So I created this ebook called Legally Departed. This is how we're legally departed by the Supreme Court, and then the police carry out that execution. So each page, this is Sitz versus Michigan State Police. It'll show you the ruling and it'll give you a little synopsis. But there's Elijah McCain and Chinedeo Kobe. They were both killed by Terry versus Ohio. Your Miranda rights, it's just filled full of cases that you absolutely have to know. And then it does attach people. Florida versus Harris. One in custody, the dog barked, that's probable cause. So the ebook is $1. And if you don't have the dollar, then send me a DM and I'll give you the book for free. All right? When I see